Good morning. We'll talk about 30 minutes this morning about how to protect your brand on the internet and when you try and sell products worldwide. We call it global protection. I'll just go at the beginning about some few organization stuff. That's me. I am a lawyer, an attorney, licensed both in the United States and Canada. I do practice fashion law, which means that I work mainly with fashion designers, fashion bloggers, fashion models. There are some areas where I specialized. I also do what's called complex litigation. And complex litigation is usually something that we do have in the United States mostly, and it's class actions. That's when one, let's say, brand is sued by a group of consumers and they consolidate the litigation as one. Usually those are like $1 billion litigations, and it's a place where nobody wants to be. But the fun part is that we do consult with other fashion designers on launching their brands in North America, both in Canada and the US, and we have quite a few successful ones. The presentation today is not legal advice. We have to say this, we have to put it there just to let you know that if you have a question, we'll try and answer the question. However, we'll just limit the answer. Well, I will try and answer the question, and I will just limit the answer to the information you gave me. That would not give you a complete answer, but it will give you an idea. So don't rely on it. Don't go back and say, well, I heard that guy, he was speaking English, and he said that I should do this. Try and run it by us one more time, or run it by a local lawyer, or run it by somebody who would look specifically at your case and tell you if that works for you or not. So a little bit about today's presentation. We'll talk about your brand's value, and when I say your brand's, it doesn't have to be a fashion brand. As you will see later, it can be your personal brand. We'll talk about copyrights, trademarks, and patents. Patents is one of my favorite subjects, and when we get there, you'll find out why. You can monetize patents very well. Social media and brand engagement and influencers, as well as celebrity endorsements. That's going to be our next topic, and we'll end up with some best practices. Now, the reason why I'm here, I mentioned I'm a US and Canadian attorney, and I'm in Riga, Latvia, Europe, is because the retail is changing in North America. I assume it's changing in Europe as well. It's probably changing here, but it's changing big time in North America, both in US and in Canada. And you have these, big retail stores moving online. So you probably all heard about these major American stores like Nordstrom, Saks, Hudson's Bay, Lord & Taylor, and of course Macy's. This is Macy's in Times Square. It's a huge store. I think it has 9 stories and 1 block wide. So massive stores. But in our days, these are the titles that you can see on the internet. So Nordstrom is firing people, Hudson's Bay is laying off, and Macy's is cutting jobs. Why? People are not buying from these types of stores anymore. They are trying to move online. People are trying to make the shopping experience more convenient than driving to the store, parking the car, and so on and so forth, right? So what we are looking at, it's not necessarily online 100%, but we are looking at new concepts and new ideas where the same big companies that we talked about before, like Nordstrom, would have a different type of stores. And this is a store that launched in, I think, 2 weeks ago. So 2 weeks ago, Nordstrom opened the first clothing store without clothes. And if you can see there, you can have a manicure at the store. You can try some new wine, and it's all free. So what Nordstrom is doing, the store is staffed by consultants. You would go in, you would browse online, and they'll tell you what clothes they recommend. Then you order the clothes online, they'll ship it to the store, you'll go back there and try, and they'll do alterations, and so on and so forth. So they don't carry any stock. If you go inside, you won't see clothes. But they welcome you shopping online. And shopping online is a different type of experience because you're not restricted anymore but the brands that Nordstrom is carrying in store. They can sell way more brands because you order these brands online and you shop to the store. So why am I in Latvia? Because Latvian brands can be present in these kind of stores. Again, you don't have to produce and send stock. You can enter into some sort of an agreement with Nordstrom where a Latvian brand will ship a small amount of merchandise or will ship based on the number of orders they receive. Now, you'll ask me, how is it possible? I don't know. This is very new, just opened. I'm not sure how many customers they had yet. It's a new concept. They have great ideas. Macy's is looking at something similar, having local stores with no merchandise to stock. Now, this is the future. So is it going to work or not? I have no idea. They paid consulting firms considerable amount of money, and they are saying, yes, that's the future. This is what's going to be. It's 2% square footage from the square footage of a regular Nordstrom store. So their costs are going down. The selection of merchandise is going to skyrocket. Okay, so going back to your brand's online presence. And again, a brand can be like a clothing brand, or it can be your personal brand as an actor, a model, or really, sky is the limit. And I selected a few things that every brand should have. One of them is a domain name, website, some listings in Google, for example, some social media pages. And when I say some, I would refer to probably different platforms, like Facebook, Instagram, Twitter, VK, blogs, one or multiple, review website. I'm not sure how popular are the review websites here, but they are quite huge in North America. So being on a review website and having good reviews is part of every brand's online presence, as well as third-party social media. And third-party social media are retweets, reposts, and so on and so forth. Now, the value that you create online as a brand, of course, your domain appreciates. And I gave you as an example our domain. And when we decided to purchase this domain name, we looked at it and said, well, fashion.law basically says everything about what we do. We do fashion and we are in the law industry, so that law works okay for us. And because we do fashion, it's fashion.law. A catchy trademark, a catchy domain name appreciates as a trademark. And you can use it and people would relate to it. Original content for your website, that's something else that you need and that's part of your brand's value. And we'll go a little bit later over ambassadors and followers. Now, trademarks. Since we are just a few here, I'm just going to ask the audience to show hands if they want to raise hands, if anybody knows what a trademark is. Raise a hand. Okay, we'll have 1, 2. Okay, we have 2 people. Perfect. That's the symbol that you'll see next to an element that's trademarked. And what's a trademark? Basically, it's what they say, it's a source identifier. Basically, a consumer would look at the product, will see what's written on it or the color of the box or anything like that. And they'll say, oh, I know this product, right? So you can think of the Coca-Cola logo. It's not in fashion, but it's quite prominent, right? Or you can look around and you can see Sony right there across the street. If you look at that name with the specific font, you know that those products are Sony Electronics and they are coming from whatever Japan, and it's a certain quality associated with that brand. The purpose of a trademark is to avoid confusion, right? You don't want to have 10 brands being named Sony. And that's why what we do advise people, register your trademark. That's quite important because the trademark is like any other piece of property. So you have, I don't know, a car, or you have an apartment, or you have any piece of property you can think of, right? It appreciates over time if you take good care of it. It goes down in value if you don't take good care of it, right? Like your car, it may be quite old, so it's not as valuable as it was at the beginning. Or, if you have a vintage car, it's even more valuable. The same is with a trademark. It's part of property that your company or your brand owns. And you can sell it, you can lease it, or you can manage it through various type of other agreements. For example, Sony is producing electronics in various countries, and they are licensing their trademarks to producers, and they are monitoring in the same time the quality of the products, right? So I just chose Sony, but think of any other firm or any other company in the fashion industry, Gucci. Gucci is not producing anything, or Hugo Boss is not producing everything in the same factory. They're just using their trademark to monitor what's being produced, where it's being produced, and where it's being sold. And I chose Hugo Boss because I saw a store right here across the corner, and I know they are producing in Latvia. So it's a German brand, and if you go in this store here, you'll see that everything is branded as Hugo Boss, as the German brand, but if you look at the labels, you see made in Latvia. So the way they do it is because they register their trademark and they manage it properly. The registration of a trademark is based on what's called use. You cannot register something that's not yours, or you don't use it. And through the Madrid system, you can register the trademarks in 116 countries as long as you use it in one of them. So let's say you have a small brand which is local and you still want to make sure nobody else registers it in any country you can think of. In the United States, for example, you can register through the Madrid International Trademark System in all the other countries. And sample of trademarks, Donna Karen, for example, and the reason why I put it here because it's a funny story about Donna Karen. That's her name. So Donna Karen trademarked her name in a certain type of characters. The funny story is that she doesn't own it anymore. So she sold the trademark of her name. So right now, in theory, she doesn't own her name because, well, she sold it. Well, we can go deeper into this, but that's an example of a name that's also the brand. So every one of you can have your name trademark if you intend to use it and if you intend to have your goods or services recognized and attached to your name. And Christian Louboutin, everybody knows about the red sole, right? It was a big litigation in the United States. It's a little bit different than the European registration. In Europe, he registered a certain type of red for the sole. In the US, it's just a red sole. So as long as you produce a shoe in the United States or try to import a shoe in the United States that has a red sole, you have to prove that you are licensed by Christian Louboutin. Right? You cannot produce a red sole with only one exception. And this exception comes from a case where Yves Saint Laurent decided to produce a shoe which is red in its entirety. And of course, Louboutin sued on trademark infringement, and the court said, well, that would be the only exception. So if you have a shoe that's red in its entirety, you can sell it in the United States or Canada for that matter. But other than that, if you have a red sole, it has to be Louboutin, because you want people to recognize who's wearing Louboutin and they're walking on the street. Well, that's not necessarily the reason, but you can fairly say who's wearing Louboutins. And again, the color is a trademark. It doesn't have the little R on it, but it is registered and protected. Now, copyrights, not my favorite. You can copyright your website content, and that's usually useful. I looked at a couple of Latvian designers before coming in here. Most of the websites would have a copyright notice at the bottom. However, I couldn't find any copyright registration. Usually we advise people to register it. The simple sign that you see right there, well, it says copyright 2017, does not necessarily protect entirely your work. You would have to register, and usually it's very inexpensive. In the United States, you can register your website and register the copyright for your website for $50. That's 30 euro. And that, again, protects the content from being copied by anybody else. Some other examples, and you will see here, are graphic and sculptural works. And when I'm referring to this, there is an example of a belt buckle, as long as you can show that the main purpose of it is not to keep your pants together, but to show some form of artistry, then it is protectable by copyright. And the chevrons on the cheerleaders' uniforms, well, cheerleaders are not necessarily very popular in here. However, this was a case that was decided last year by the Supreme Court of the United States. As you can see, the difference between the two garments, one is the original and the other one is a copy. And of course, the owner of the original copyright sued and said they copied. And the Supreme Court of the United States had to decide if the elements on the garment are artistic or they are part of the functional part of the garment, right? The company that copied the design said, well, it's functional because it's for cheerleading. If it wouldn't be a chevron on it, it wouldn't be for cheerleading. But the Supreme Court didn't buy. They said, you copied it. You can functional means without it you cannot use it as for the purpose that was intended. So you have a T-shirt. Functional is the fact that it's a T-shirt. If you cannot use it as a T-shirt anymore, that's not functional. But whatever you write on a T-shirt, that's protectable by copyright. And now, to confuse you even more, everybody looks so confused, I'll go to patents. And as I said, this is my favorite type of intellectual property protection because you can monetize it very well. And there are few companies or people that will really go into arguing with you. I'll just keep and give you an example. This is called Lululemon yoga pants, right? And what Lululemon did, I'm not sure if anybody heard about Lululemon. Nobody? Okay. It's a Canadian yoga wear brand. It's a sportwear brand. It's based in Canada, in Vancouver. They are quite big in the United States, but the way they became big, they started to register patents for their designs. And I think in 2015 they were making more money from exploiting royalties on these patents than from actually selling clothes. As you can see, it's nothing that you couldn't think of before, right? It's just a design that they wanted to register, and they did register. And of course, Calvin Klein, a couple of years after, they came up with the same design, right? And Lululemon left, didn't say anything for a couple of years. Calvin Klein sold quite a number of pants. And what happened according to the US law, if somebody is infringing on your patent, they are liable to you to the extent of his total profit. So what happened with Lululemon, after a couple of years when Calvin Klein sold their pants, they went back and said, well, how much money you made on these pants? Whatever the amount was. They said, well, you owe us the entire profit. So all the money you made, you give it to us because we had a patent. And it was your responsibility to check and make sure you're not infringing. At this point, Lululemon owns the most US design patents. So if you think of all the companies, they own the most. And they have patents for everything you can imagine. And they are licensing it. If somebody, they have a patent for gym wear with a hole for the finger, you know, the one that you put your finger through in a sleeve. They have a patent for that. So every time a different sportswear brand has some sort of a hoodie or a jacket with a hole for the thumb, they'll have to pay. Either they pay a license fee to Lululemon to use that design, or they are liable for 100% of their profits. Now, going back, so as I said, that's the part I like about the patents, because you can be creative. Anything that was not registered is wide open. You can go there and register anything that's original and was not registered before. And if anybody will use it, next year, 2 years from now, 5 years from now, you have a 15-year term for your patent, you can go and ask 100% of the money they made. Now, in the United States, as I said, it's 15 years, so your patent's protected for 15 years. After 15 years, it becomes public domain. So after 15 years, that Lululemon pants, everybody will start producing it, which is not true. We are talking about fashion. We're talking about seasons. Nobody's going to care about that in 15 years from now. Probably nobody cares about that in 5 years from the moment Lululemon registered, because, again, fashion is changing. But that's another reason why I like it, because I think it protects your design until the end of its life. Again, if you look back at the 80s, I don't think people are producing right now anything that was registered back in the 80s or the 90s. And this is a sample from Skechers. So the Skechers register that design and this design as patent designs. And of course, Perry Ellis, we don't know if they got inspired or not. They produced a sports shoe that resembled with the design, so you can see the resemblance. Of course, Skechers sued, and of course, Skechers was compensated in a settlement by Perry Ellis. The heart that you see on the sole was also registered as a patent, and you have the patent number there. And Paris Hilton decided to have a shoe with a similar heart. I'm not sure if you see it here. And of course, she got sued for patent infringement. And they settled. We don't know if she paid 100% or 90% of the money she made, but probably her attorneys got fired after that because they didn't check on an existing patent. And again, it's not something extremely complicated. It's a heart on the inside of a shoe, on the sole, on the upper sole of the shoe. It's nothing extremely complicated. And still, if Paris Hilton comes up with the same idea and doesn't check if the idea is registered, she's liable.
Yes.
Okay, go ahead.
It should be the same size?
No.
Or just the idea?
Okay. Well, if you look in this one and this one, they don't look exactly the same. The shape is different. So Paris Hilton's shape was more elongated, while the registered design was more of a symmetrical heart. It doesn't really matter. The same happened here. If we go back, if you look, it's not exactly the same idea because the size of these things are not necessarily equal with the size of this. The number of circles here is different than the number here. However, they looked at both patents and they take it to court, and they told the court, well, if you look at them in between, what Perielis did is infringing, either on one or the other or a combination of both. So they were not necessarily in this case able to say, well, they copied exactly that thing, right? They were not able to say they copied this thing. They just said, well, they looked at us and they copied what we created. And that was good enough for the court. I don't have the copies for this, but you can imagine how easy it is to copy this. And again, you don't have the distance in between there doesn't have to be equal or whatever. It's, if you can see here, it's the two stripes are at equal distance. It doesn't really have to be. It has to show somehow that they got the idea from you. And to be honest, searching for trademarks is not easy, right? You have to search, you have an idea, you want to produce something, right? I don't know, you want to put a butterfly on a hat. And then you would have to search, you'd have to go to, let's say you want to sell in the States, and you would have to go and check butterfly and hat, but sometimes it's not as easy, right? You want to see if your specific butterfly is on a hat, and then you would have to see, okay, somebody registered this idea or not. And then if somebody registered the butterfly on a hat, maybe it's a different type of butterfly, or maybe it's a different type of hat. And you have to work with the elements that you have. Okay, right of publicity. What I did last night, I just went online on some not known websites and picked two pictures. And the idea is that I doubt that any of these models wanted their photo on that website. I'm not sure if you can see Oksana's picture here. This is written in Chinese, and she has some branding, she has a stamp right there. Okay, and this is from an Amorale. I think they picked it from their website. And I'm not sure if Oksana still works for them, but she was the face of Amorale, I think, a couple of years ago. So normally, both of these are like famous or quite famous models, right? And normally your mother agency, if you're a model, would look after monetizing and usage of your image. However, it's up to everybody to keep track of their image online. And when I say that, it's quite important to keep an eye on who's using your material, who's using your pictures, regardless which industry you're in. If you're a fashion designer, it's quite important to see what site and where are they based is trying to use your material to sell something else. And it's not so very complicated to police, and we'll go over a case quite fresh from Canada where a Canadian court said it's enough if in your country you try and stop it, and then you should be able to stop it worldwide. I'll answer more questions about that if you want. Celebrity endorsements is somehow connected. What I did here again, I went to a website, well, actually to a media profile called MLH Shop. MLH is a brand based in Eastern Europe, and they are dressing quite a few celebrities in the United States. And if you look, I think this is from their Instagram profile or Facebook profile, they're posting pictures with celebrities dressed in their clothing. And again, they are not based in the United States. However, they are using a US-based platform, which is Facebook, in order to do that. Now, when you open an account with Facebook, they will ask you to check there that you agree with their terms and conditions. One of them is that US law applies to whatever you do on their platform. Now, because you're in Latvia, they'll ask you to pick another one saying Latvian law applies as well. So while you're on Facebook, if you want to keep your account open, basically you have to abide by both US and Latvian law regarding everything that you post in there. And anybody know who this actress is? Katherine Heigl? Perfect. So what, you can see a picture here, sorry. She went to a store, and it happened she went to a Dwayne Reed store. Dwayne Reed is a big chain in New York City. It's type of a Maxima or Remy, right? So she was doing her grocery shopping. And Dwayne Reed said what it says right there. So that was their tweet. Love a quick Dwayne Reed run, even Katie Heigl, and they tagged her, can't resist shopping at New York City's favorite drugstore. I gave you a preview. Do you know what happened next? What? You have an idea. Okay. This is what happens next. $6 million. The Dwayne Reed was not authorized to use her picture or her image in order to promote their store. We don't know if she got $6 million. If you ask me, I would say she at least got free. Because they settled before it went further. Usually, lawsuits of this type would cost a couple of million to litigate. So Dwayne Reed would probably end up paying $6 million plus $2 million. So if you ask me, based on my experience, I would say she got $3 million at least. So that's an example of what not to do. And people are usually asking me, what am I supposed to do? I have this celebrity, I have Beyonce wearing my dress. How can I not put that picture on my social media? I mean, it's Beyonce wearing my dress. Like, come on. And what I advise is ask for permission. Send them a quick email. Send an email to their agents. Can I post this? Just want to make sure I don't have to pay you $6 million afterwards. And if you have a yes, post it. If you have a no, don't. Wait until they post it. And advise people to go and look at it there, right? These kind of things also apply to reposts, right? If somebody posted a picture with Katherine Heigl and you repost it with your notes underneath, right? So let's say she posted on her own profile this, and then Dwayne Reed reposted the picture, retweeted with their notes on it, that wouldn't be okay either. Because they are using something that's online for one purpose, for their commercial purpose, which is not the way it should be. Okay, let's go to more interesting things. Well, it's more interesting. It's still, let's learn from some mistakes, right? Again, once you are on Facebook and Instagram, you are clicking that box that you would follow the US law and the terms and conditions. And everything that we're going to talk about is part of that, right? And I know that it's going to be a little bit more of a US enforcement procedure, but the principles are the same here. And the principles are those that you have to follow in order to be able to keep your account active, for example. Because closing Facebook account is the easiest thing for Facebook to do if they believe that you infringed on the terms and conditions or US law by that matter. So this is how people are usually engaging in social media, right? They get endorsements, likes, followers, likes again, retweets, reposts, or just simple posts with their product or with their image. And in the United States and Canada, and I think it's quite general for that matter, if you say something online and you advertise for somebody, you have to disclose it. And right now in the United States is a big movement towards a hashtag ad, that's AD, showing that's an ad. Not necessarily the right way, but at least more and more bloggers are using hashtag ad. Now, again, in the United States, speech is protected, which means you can say anything you want to anybody you want, right? You don't like the president, you can go anywhere you want, on TV, in a newspaper, or in a public place, and say, I hate the president. And that's fine, right? But there is one exception, and the exception is commercial speech. If you go and say, buy this product for me, or you do anything commercial-wise, that speech has to be truthful. And I'm not going to go over... By the way, do you have the Bachelorette show in Latvia, or you know what I'm talking about? No. You do? Maybe. Okay. Well, there is a Bachelor/Bachelorette show franchise that originated in the United States. She's one of the winners of the Bachelor contest, and she's saying that she's using Pond's for 10 years, and her skin is so good and perfect, right? What we did, we looked at every single winner of the same contest, so it's a reality show, and everybody's basically using Pond's for 10 years, and their skin is glowing and fine. So the question is, yes, it's commercial speech. They would probably put a hashtag ad somewhere. Well, is it truthful? We don't know, but that's for next time. This is an interesting case. And again, it's just to give you an idea about how things work in the United States. And it's quite late. It's quite old. In 2015, Lord & Taylor, if you remember, it's one of the big department stores, wanted to promote their own label called Design Lab. And, it's targeting women between 18 and 35 years old. And they used fashion influencers, which means, bloggers and Instagram personalities, to promote this product. So what they did, they chose 50 people. They paid between $1,000 and $4,000 to all of them, to each one of them, to post a picture on Instagram showing themselves wearing the dress. And these are a couple of examples. That's one of them. That's the other one, right? They're wearing the same dress. They got between 1,000 and 4,000. And as a result, they had 11.4 million Instagram users saw the post, and 328,000 brand engagements, right? The dress sold out, needless to say. Everybody wanted the dress. Now, as you can see here, the source for this information is an FTC complaint. Federal Trade Commission is the U.S. regulator for trade and advertising. I'm not sure what's the Latvian equivalent, but again, being the fact that both Lord & Taylor and Instagram were both in the States, FTC had jurisdiction. And these are the bloggers. As you can see, they're all wearing the dress. And they are all saying, that's the best dress I ever had. And none of them is saying, I got $1,000 for it. Or that I got a free dress. Now, what happened in that case? FTC launched a complaint, and Lord & Taylor had to pay a fine. Of course, they settled. We don't know how much the fine was. They were able to keep their Instagram account active because they presented a copy of the settlement agreement to Instagram, and they asked Instagram to allow them to maintain the account. But that's not necessarily the case for everybody. Sometimes brands don't have money to settle. Sometimes FTC, because there are no settlement funds, would move forward with enforcement actions, which can be, fines, closing the Instagram account, and so on and so forth. Now, there is a question here regarding advertising. And, if you're a blogger, do you have to mention every time you have a product on your blog, if you are paid or if you got the product for free? And what FTC is saying, and that's copied from the FTC website, is we don't really care if you paid for the product or not. What we care is what's in your mind. If you really like this product, you bought the product or you received it and you're going to send it back, but you really like it and you're honest, then it's okay, go ahead, advertise or whatever. put your honest opinion there. If you're making some money or you're getting any kind of other benefit, don't. Don't do it, disclose it, put a hashtag or not a hashtag, just let people know this is advertising. They sent me the dress, they gave me $1,000, and that should be enough. Now, some statistics are quite old. However, I believe that the percentage didn't change. It says 1 in 7 recommendation or ratings on social media would probably be fake. And I assume 1 in 7 is still accurate. The reason why I put the 2 Instagram texts in there, as you can see, one of them added hashtag ad. And this is quite recent. We just looked again at the same bloggers from before in 2017. Some of them didn't bother changing it because the FTC complaint was against Lord & Taylor. Some of them added hashtag ad. Now, selling in the United States. That's a topic by itself. I can speak probably for a few hours about what should you do to sell in the United States and how to comply. It is important to understand that selling in the United States, if you have an online store and somebody buys something from the United States, that product has to comply with the rules existent in the United States, right? And this is just a simple example, and this Proposition 65 in California. Every garment that's to be sold in California has to have this warning on it, right? And basically the warning says that the garment may contain chemicals known to the state of California to cause cancer or birth defects. And if you ask me, every zipper, every piece of leather, every trim, and so on and so forth. So it's hard to find a product that won't need to have a warning like this. Now your question is, okay, well, California people are weird. They see this warning on everything, so they are used to, right? But how about if I'm putting this warning because I want to sell this product in California and I'm shipping it to Germany and somebody looks at it and says, oh my God, I'm going to wear this sweater and I'm going to get cancer or birth defects, right? Because it says here. And that's an open question. What we usually advise people is try and comply with everything you can. I know it's very bad marketing, putting a warning that this product may cause cancer, or don't sell in California. That's the case I told you about. This is a 2-month-old case, and it happened in the United States. And the reason why I'm telling you about cases is because this is how we create the law in the American, British, Canadian system, right? And this is the first case worldwide when a company sued somebody who was selling fake products and said, my intellectual property, my trademark, my patents, whatever, are infringed by a company that's doing this. So instead of Michael Kors, he's selling Michael Kors. And what we want Google to delist this company from all of their searches worldwide, right? And it took a number of years until it went all the way up to the Supreme Court of Canada. However, what the Supreme Court of Canada said is, yes, we order Google to delist the counterfeiter from every single search in every single country they are present. And it was, as you can imagine, a big deal about it, right? People are asking, well, how can a Canadian court order Google to delist a website from a Latvian search engine? And again, Canadian Supreme Court was quite strong and said, well, if you don't want to delist it in Latvia, let us know, and then you'll see. And they believe that they have enough power to force Google to delist sites like this from their searches worldwide. And that's very new, and it means something. It means that you can police your mark in one country, and that would have you using that, you can influence the way, for example, Google or Facebook works in other countries. Okay, very short because I'm almost out of time about online giveaways. It's okay to do it here if you do it on Facebook or YouTube. Pay attention. In the United States, they are considered lotteries, and lotteries are illegal unless you have a license to organize a lottery. And what's a lottery is when you ask something in exchange for a chance to win. And something would be, like in this case, buy my products or even follow us. If you request somebody to follow you in exchange for a chance to win, that's viewed as a lottery. And Facebook is catching on enforcing that, the same with YouTube, with people requesting an action, requesting something of value in exchange for a chance to win. Best practices. Oh, anybody recognize the picture? Okay, you know who she is. There is a show. It's in the US. I think you can find it online. It's called 73 Questions or 74 Questions, something like that. And Taylor Swift was asked all these questions, right? It's a rapid sequence. It's done by Vogue, I think, right? And one of the questions is, what advice do you have for new musicians trying to enter the market? And her advice was, find a good lawyer. And I personally trust this thing from Taylor Swift. I'm not sure if I trust anything else from her, but this was good advice. Other things, be honest with your followers, try and have new content all the time, ask for permission before posting somebody else's picture, disclose paid advertising. And that concludes today's presentation. We do organize seminars all over the world. Next time, well, I have it here for the next time, but right now I think it's time to go and eat. We can talk about creating an international corporate structure that's even more interesting than today's presentation, so we hope you'll all be there. So right now, questions. I know you all have questions. So. No? No questions. Okay, well, I'll be sticking around. It's 12 o'clock, so I promise that we'll be done by 12. And